Thank you, Professor Mazzone, for a great talk on Obamacare, or the Affordable Care Act. As a first question, can you outline the main issues that the Affordable Care Act sought to address?
Sure. So the Affordable Care Act, which was enacted in 2010, is the landmark signature legislation of President Obama's first term in office. It sought to deal with two big problems in the United States that pretty much everyone thinks needed to be addressed. One is massively increasing healthcare costs in the United States, and the second is the problem of huge numbers of Americans, around 50 million of them, who lack any kind of healthcare insurance.
Now, there have been a number of challenges brought forward against this statute. What are the constitutional arguments put forward against the Affordable Care Act?
So the Supreme Court decided a case involving two specific arguments. One, perhaps the most important, was the individual mandate requirement of the Affordable Care Act, which says that virtually all Americans must have a health insurance policy, or else they're going to be fined, face a penalty that they have to pay to the federal government. The Supreme Court upheld that provision of the statute, held that the federal government could indeed force Americans to purchase a health care policy. The other issue before the court so far has been whether the federal government could require the states to vastly expand Medicaid coverage to include millions of additional poor individuals, extend health care coverage to them. The Supreme Court said that the terms of the Affordable Care Act in that regard were unconstitutional.
Now, there are some new cases coming up in which the Act is challenged. What are they, and what are the grounds that they are based on?
We have some really amazing and interesting cases involving challenges to a requirement under the regulations issued by the Obama administration pursuant to the Affordable Care Act that say that insurance policies provided by employers must include coverage for contraception. And there are a variety of employers in the United States who object to this on moral, on religious grounds. Initially, objections were made by churches, which have employees, and then universities and hospitals and other entities that are operated by religious institutions. And now, most interestingly, we have the same arguments, religion-based arguments, made by for-profit corporations. The Supreme Court has shown in the past few years a very strong interest in religious rights, as well as a very strong interest in corporate rights. And so in some ways, this is the perfect storm for dismantling an important provision of the statute. So the fight really goes on.